Good morning. This is Rich Sierra. I'm the president of Florida Small Business Legal Center. This is episode 39 of Business SOS. Thank you for listening today, whether it's morning or afternoon. Thank you. Today, our topic is going to be, and I'm kind of going in a series in what's called Discovery Series. I talked about subpoenas a few weeks ago, whether you get served. I'm talking about interrogatories, production request. So I'm going to today, the topic today is going to be, my deposition is next week. What should I do? And I'm going to talk about in the context of you being the plaintiff, the person who's suing, or from the context of you as the defendant, the person who is actually being sued. So if you're a party to the lawsuit, after the pleadings are filed, you filed your complaint, your answers, and your affirmative defenses. And then there's going to be what is called a discovery phase. That's the phase that your attorney is going to basically get information from the other side through interrogatories that are sworn interrogatories, requests for production of documents as well, and also requests for admissions, and also through maybe third-party subpoenas that you basically request from third parties, witnesses that may have information about the case. You ask for documents from them, or perhaps ask for a deposition of a non-party to the lawsuit, because that individual may have information that is relevant to the case that the plaintiff or defendant is trying to pursue. So today, and as part of this discovery process, it is very likely that you as the party will be deposed. So you will basically have, your attorney say, your deposition is 2 weeks from now. In this particular case, saying it is next week. And what should I do? And your first question to your attorney, if you've never been involved in any type of litigation, is going to be, what is a deposition? So let's talk about that. A deposition is basically an out-of-court. It is a court proceeding, but it's not in the actual trial. It's not in the actual court. It's going to be at an office. Perhaps now we're doing via Zoom, via video conference. But it is that you're going to be answering questions under oath that are asked of you by the opposing attorney. It can be a very intimidating process. And so we're going to talk about how to prepare. I'm going to give you 7 tips today on how to prepare for this deposition, what it is, and how perhaps put your mind at ease, and give you some tools that you can work with to have a productive deposition. So yes, it is an adversarial process, and the objective of this deposition, if you're the one being deposed, in this particular case, you're the deponent, the opposing side is trying to gather information to help his or her case against you. So that is the objective of the deposition, is to gather evidence, obviously to gather facts, but also gather evidence that they can perhaps use in a motion for summary judgment against you. And we'll talk about what that is at another episode. Evidence that perhaps find contradictions in your statements, perhaps contradiction from other witnesses. Again, it is the objective of this deposition is to gather evidence that could be used against you at trial, or perhaps at another process to finish the case against you. So if you have not done this before, it could be an intimidating process, because hopefully you're not going through a lot of depositions in your life. It's just not a fun process. Even if it is your case, it is not fun because you're basically there asking questions under oath. So it's part of the discovery process, and that's what's going to happen. So let me explain to you how this will work, the actual mechanics. So if it's a virtual deposition, you'll be in your home or an office, or perhaps your attorney's office with in front of a camera, or now the PCs that they'll have video cameras now. So it'll be through a Zoom or another type of video platform. You'll have a co-reporter appearing at this deposition as well that will retranscribe word for word everything that you say. at this deposition. You'll have your attorney present, and then you'll have the opposing counsel present as well, who will be the one asking these questions. That's it if it's in a virtual Zoom conference. If it's live, you're actually in person, you'll be in a conference room for the most part at the opposing side's attorney's office, or you will have perhaps in a deposition a company that actually has a conference room. Most of them do, and they'll provide the facilities. It'll be comfortable, and then you'll be there with your attorney. The opposing side will be there as well. Maybe the opposing party will be there. They're entitled to be there if they want to. But most of the time, the parties do not show up to depos. It depends. So that's kind of the staging of the deposition. So understanding now, the first thing I want you to do is to understand what is the deposition and what it is for. It's to gather evidence against you, to use a trial, or perhaps in a motion for summary judgment, or any other proceedings in the court. So once the deposition is finished, the attorney can ask for a copy of the transcript. So all your words, everything that you say will be transcribed and sent back to him in a report, in a transcript. They also have the option to do a video deposition. So everything that, even though it's taken by video, but if it's not recorded, then that will not be utilized. But you can also have a video deposition as well. How do you prepare for this deposition? Okay. The preparation for deposition is essential. And it is also good for you, but it's also good for your attorney. It is also better for the case. If you're the one, being sued, you want to prepare well for this depo. And either one, whether it's being sued, you're suing, prepare for the depo. How do you prepare for this deposition? It's good to have a meeting with your attorney beforehand, obviously, the depo, and talk about the types of topics or questions that you will be asked in this deposition. So you're familiar with them, because the reason is you're going to be answering questions under oath based on your personal knowledge. That's very important. I'm going to repeat this. You're going to be answering questions under oath based on your personal knowledge, meaning that you're not supposed to guess. You're not supposed to try to speculate or try to figure out, oh, this is really what he wants me to answer. No, it's based on what you know at the time. Sometimes people forget things. So it's about what you know at the time. There might also be documents that may refresh your recollection. So part of the preparation is not only going through the topics or the types of questions that you may be asked, for you to understand them, be familiar with them, and also be prepared to answer them, and actually makes the deposition go faster that way. But also the types of documents that most likely you will be asked to talk about them. It could be an email that you sent to the opposing side. It could be an email that you received from the opposing side. And the reason it's important, it's good to review these documents, again, is because very likely you are going to be asked about them. And by having knowledge of those, you can answer the question, and it'll make the deposition go faster. The faster this deposition goes through, the more efficient it is, the better for you, because you'll be out of there faster. So the objective is to answer the question, let the opposing side take deposition. They're entitled to that, just like you're entitled to take their deposition as well. But at the same time, just be prepared, because it makes things go faster, more efficiently, and actually helps your case by being prepared. The attorney will explain to you some of the rules, and I'll go briefly over them. In terms of the rules, is based on your personal knowledge, not guess. Answer audibly, so the court reporter can transcribe your answers correctly, meaning do not use sounds like a hum or nods, simply because those things will not be able to, the court reporter will not be able to transcribe that correctly and accurately. If English is not your primary language, you understand it, but it's your second language, you can also tell your attorney, listen, I'm not really comfortable with taking the plea in English. Portuguese is my primary language, or Spanish. Can I have an interpreter? You can request an interpreter, and the other side has to provide an interpreter that is certified. And then you can have an interpreter there, interpreting the questions for you. You answer in your native language. The interpreter will answer the question in English. What the interpreter says goes into the record. So it is good to have an interpreter there, but you still have to make sure that interpreters are human beings as well. Sometimes, and because I'm bilingual, I speak Spanish as well, sometimes interpreters do not get it right. So we have to be careful with that as well, because it's not what you're saying in your native language going to the transcript. It's what the interpreter says in English, what goes into the transcript as your testimony. So we have to, talk to your attorney about that, whether you can actually answer in English, or perhaps you need to interpret as a conversation that needs to be had as well. But also remember that the deposition will be longer by doing that, because basically now you're having a three-way communication, because you need to allow the time for the interpreter to listen to the question, ask you the question, and then answer the question in English. Wait for your response, and then answer the question in English. So it takes a little longer to do a depo through a interpreter. Nothing wrong with it. I mentioned reviewing relevant documents. Again, we're talking about emails, contracts, memos, any correspondence, text messages, anything. Also, if you answer questions, you produce discovery. If you answer questions in your interrogatories, review those questions, because you're going to be asked about those questions. If you produce documents, pursuant to request for production of documents, review the documents that you produced. If you answer requests for admissions, review those. The more prepared you are in the case, the better. If you're the one that was sued, review your answers to the complaint and review the affirmative defenses that you raised. And it's important to review the affirmative defenses, because you will be asked about those. And a lot of times, attorneys, we write affirmative defenses of the complaint. They're legal defenses, but the clients do not understand what they are. And then when they're asked, do you raise this defense of this charge in a contract? They'll answer, for the most part, will be like, I don't know what that means. So it's important that you understand what your attorney raised in the affirmative defenses, so you can also answer those as well, based on the facts. You have to understand the do's and don'ts of the deposition. And I want to talk about some of the mistakes that people make in depositions that do not help the process. One of them, obviously I mentioned one already, is that answering through sounds or nods. It's just not a good idea to do that, simply because it makes the attorney repeat the question. It makes the deposition longer. Number two, if answering a question that it is not clear, but you think it's what the attorney asks you. And what happened is that you're kind of trying to help the attorney, by coming up with an answer that this is what I believe you asked. So my rule is this: if you do not understand the question, ask for a clarification. We attorneys, we try to ask questions as clearly as we can. Sometimes as we are developing this in a live moment, sometimes our questions do not come as articulated as we would like them to be. So sometimes we come up with confusing questions. So if you do not understand the question, say, I'm sorry, I'm not ready. Can you please clarify that question for me, or repeat it, so that way you can answer the question properly. Also, it's important to allow not to answer the question while the other side is speaking. If the attorney is asking a question and you already know the answer, for example, can you please provide your address? You already know the answer to answer the question, but you start speaking before the person finishes. What happens, the court reporter can only record and transcribe one person at a time. So I just gave you a basic example, but a lot of times people try to anticipate the question, and because you're nervous, you kind of like want to volunteer and begin to ask, answer the question before it's actually finished. So let the attorney ask the question, take a pause, and then just basically answer the question. Another mistake that I see some people make in depositions, they volunteer too much information and they expand. So it's important to listen to the question that is being asked and answer the question that is being asked. Sometimes people want to explain, they want to, quote unquote, try their case in their deposition, and they go into a narrative. And I understand that people want to tell their story, but sometimes it's not advisable to do so. Not in a deposition, because it is part of the record. You can tell your attorney the story, answer the question truthfully under oath, but only answer the question that you're asked. Nothing more, nothing less. There's no need to expand or provide explanations and self-explanations, because it becomes a narrative, and then what happens is the attorney's going to say, fine, just keep talking. Because then from that information, sometimes people volunteer information, and then from there, a good litigator is going to take some of that information and go into that particular topic because you brought it up. It happens in almost in every single deposition. The opponents volunteer information, and at that point that you were not aware of, the attorney was not aware of, and then at that point, you have a whole different line of questioning based on some answer that was not even asked in the first place. So just keep that in mind. Listening is important, pausing is important, and answer the question truthfully based on your personal knowledge of the question that was being asked of you. Another mistake that I make sometimes, that some clients make or people in depositions make, is that they get angry at the attorney, and I understand that. Okay, that the attorney is suing you, or you basically, the attorney is defending the other side that you have a problem with. It's fine. But arguing with the attorney based on the question, or being sarcastic with the attorney, that in the deposition, it does not help the process. The more professional you are, poised you are, the easiest the deposition is going to go through. If it's an easy way to get through it, but it's a more smoother process. Just, you might not like the question, you might not like the insinuation. Your attorney's there in the case he needs to object, and we will object to deposition questions. We do object quite a bit, depending what the question is. But just listen to the question, answer it, keep your poise, and get through it. Now, you will have the opportunity to take breaks in depositions. Okay, so if after 45 minutes or so, and again, I'm using that as an example, you need to stretch your legs, you need a break, just tell your attorney, to tell the opposing counsel, can I take a break? Whether it's to reach the restroom, get some water, so that way you can get back to it. Okay, so it's okay to take a break, but it's important to take a break after you answer the question, so that way there's not a question hanging before you come back. Just close that question and answer cycle, and then go ahead and take your break and then come back. Throughout the deposition process, your attorney cannot help you. Okay, so there's no coaching, there's no communication with your attorney during that time. Before, after, yes, not during the time. So you're on your own at that time. He'll be there during the process, objecting and defending the depo, but he cannot, during the course of the deposition, there's no communication between you and your attorney. That's why preparation is critical in this case. Some attorneys do this. It's not really my practice, but some attorneys do it. They do practice depositions. Some people find it helpful. And the idea is to kind of give you a flavor of what a deposition will look like, and more of to prepare psychologically for it. That's depending of whether attorneys want to do that. Obviously, I think preparation is more important. than actually doing a practice run. But that everybody has their preferences. That's something you need to talk to your attorney whether you want to do that or not. Every case has some situations that, no case is really a slam dunk or black and white. There are situations that might be difficult questions that might be asked of you, whether it's a personal issue, whether it's a business issue, or something or some fact that is not in your favor. It is important to address that particular issue with your attorney and really be prepared for it. The idea with the deposition that no question that is asked at the depo should be a surprise to you. That's the reason that preparation is so essential in the deposition. You know the facts for the most part better than your attorney because you lived it. You lived those facts. You lived that event. You lived the events that led to the lawsuit in the first place. So there might be an email, it might be a text, it might be something that was said that your attorney's not aware of simply because the attorney gets the information from you or from the discovery. So, but he did not live those events. He or she was not there. So it's important to share that with your attorney. Say, listen, this might come up. How do I handle it? And your attorney will explain to you, okay, we will address it this way. Okay, so just be prepared for that, and avoiding it is not going to make it helpful simply because it will increase your stress and the deposition is not going to be as effective for you as you want it to be. So it's good to deal with difficult questions right from the very beginning, and it is part of the preparation for the deposition. And if you notice that I emphasize preparation throughout this podcast, is because it's important. The more prepared you are for your deposition, the better you will be for your case. And better your attorney will be better prepared as well. Okay? There's how this preparation will help you. The depo also helps you from an emotional and psychological standpoint as well. I think the better prepared you are, the better you will perform, if that's a way to describe it. But it is an adversarial process. You're there because you're in a legal proceeding. Either you're there because you initiated the action against somebody else, or because somebody's suing you to get some relief, whether it's a negligence claim, breach of contract claim. So the idea, you want to basically be as prepared as possible. So mentally, you are prepared for this depo. So what you can do, just go ahead and, do a dry run on the Zoom call. For our mediations and depositions, when I do my preparation work, I'll make sure we'll do a Zoom presentation, Zoom conference in the exact room that my client is going to be either doing the mediation or doing the deposition. Simply because what I want to make sure is that the technology works well before we actually going live with the deposition or mediation. Those little things help, simply because if you, for the very first time, you're used to working with your phone for the most part, depositions, that's another tip I'm going to give to you. Don't do a depo via the iPhone. It's just not going to be effective. It's going to be difficult simply because they're going to be documents that are going to be presented to you for the most part. You're not going to be able to see them through your phone. It's just not going to be effective to do that. So you want to get a desktop. If you don't have a desktop, there are other ways that you can facilitate. The deposition services can provide them. You can go to their offices. There are many other ways, but those are the things that I do, is that anything you can control before the deposition, the technology, the space, you're going to have in a quiet room, have a glass of water next to you. Okay? Those sort of things. Have a good night's sleep the day before. Those are things that are going to help you mentally and psychologically be prepared for that day. And you're going to find out that by having that level of preparation, you're going to be confident and you're going to feel, if we can say you're good about taking the depo, you're going to feel confident and going to be more relaxed and be more at ease than if you basically do it for the first time. You're going to start logging in, and this preparation did not take place. Preparation is very key for a successful deposition. And then at the end of the deposition, you're going to have an opportunity, what is called to read or waive. Talk to your attorney about that. What that means is the following: that if you want to read your deposition, you believe that the court reporter took your answers accurately, and you can waive the reading, and then they'll just order the transcript, and then you accept the answers as they were transcribed by the court reporter as truth. Okay? The other option is you have the option to waive. What that means is by waiving to read the depo. So that means that if anyone orders the transcript, you have 30 days to go to the court reporter's office, okay, to basically read the depo and then correct any inaccuracies in the testimony, in the deposition. And they give you what is called an errata sheet, and then you submit it. If you change too much of your testimony in your transcript, then the opposing side has an opportunity to recall you back in to answer those particular issues, questions that you changed. So that's something to keep in mind. You discuss that with your attorney as well. At the end of the attorney who's doing the deposition, when he says, "I have nothing further," your attorney has the opportunity, what is called, to cross-examine you. I'm not a big fan of cross-examinations on depositions for my own clients, simply because I'm putting my client on the record. But sometimes it's necessary. It might be a clarification that we may have to do. It might be perhaps an answer which the attorney did not allow my client to finish, and I might need to ask that question to finish that particular aspect of the testimony. So when that, and then the attorney has the right to redirect as well. So when everybody's completed, everybody said, "We have nothing further," we finish the deposition, everybody leaves, and that's the end of that. So just to recap some of the points that I discussed today, understanding what a depo is today. Deposition is an out-of-court testimony. It's a court proceeding that you answer questions under oath to the best of your knowledge, based on actual personal knowledge. You need, my recommendation, prepare with legal counsel before that depo is very, very important. Review the relevant documents of the deposition you're going to be taking. Answer audibly. Don't answer in nods or noises, or do not guess. Listen to the question, pause, breathe, then your answer. You can ask your attorney, you want to do a practice run for a deposition. He might ask you 5 or 4 questions to give you kind of a feel of what a deposition looks like. There's also videos online that you can see, YouTube, what a deposition looks like. So there's plenty of information available out there. You can learn about what a deposition actually, how it's conducted. Handle difficult questions. Talk to your attorney about how to handle difficult questions is very important. And also, prepare yourself, do the things you can do to be as comfortable as possible in this deposition. Dress professionally. It is a court proceeding, as if you were in court. And try to get your mind at ease, get a good night's sleep, and just get through it. And you're going to be fine. Talk to your attorney, any concerns or issues you might have. At the end of the day, it's your process. It is your day in court. It's part of the process that we're in. So you'll be fine if you have a deposition. Hopefully these tips will help you if you're in a deposition, whether you are the one suing or being sued. But if you have a deposition being taken, hopefully these tips help you, get through it the best way possible. So I'd like you to participate in the show. If you have any legal questions you'd like me to address in the show, please send me an email at richsierra.com. If I select your question and I address it at the show, I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. If you're interested in learning more about our legal services, My website is floridasmallbusinesslegalcenter.com. We're in Facebook at FSB Legal. We're in YouTube at youtube.com at Richard Sierra. We're in X at Rich_Sierra. We're on Instagram at FSB Legal. If you like the show, please follow us. We're available on Apple Podcasts, Spotify, wherever you enjoy your podcasts. We're also on a YouTube channel. Subscribe as well. If you'd like to see the video of this podcast. Again, if you're interested in our legal services, to repeat the website again, is floridasmallbusinesslegalcenter.com. And our phone number is 866-842-5202. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.